Hello everyone, this is the video of Legal Studies class 12 and in this video I will be discussing unit 1 namely Judiciary and the subtopic is that is removal of the judges of the Supreme Court and High Court. So let's begin with the topic. The first question that we have today is what is the procedure of removal of judges of the Supreme Court? As per the constitutional provision, a judge can be removed only by an order of the President based on the removal motion passed by both the houses of Parliament separately. As we know that even in my previous video we have discussed that the motion has to be passed separately in both the houses and then based on that President will decide. Next provision is a judge of either High Court or Supreme Court can be removed from his or her office through a motion adopted by Parliament on grounds of proven misbehavior or incapacity. So this provision is saying that there are two grounds basically, misbehavior or incapacity. So it may be some medical reason or misbehavior may be anything. So based on that either both of them or any one of them. If it is proved then the judge of the Supreme Court will be impeached. At this point in time I would like you to note down another point, that is the process of removal of the judges is exactly same for both the Supreme Court and the High Courts. So there is no difference, literally same. At this point in time, I would like you to take your attention while defining the impeachment term basically. As more often we use the term impeachment for the removal of judges, but the Constitution doesn't use the word impeachment as such. Rather states as removal of Supreme Court judge under clause 4 article 124 and removal of High Court judge under article 217 clause 1a and article 218. So nowhere impeachment is used for the removal of judges of the either Supreme Court or High Court. So we have to understand this point that we should not use the term impeachment for the removal of the judges. Rather this term is exclusively used for the President only. Now we have the procedure, that is the procedure of removal of judges of the Supreme Court is described in the Judges Inquiry Act 1968. So there is separate act that defines the removal of the judges of the Supreme Court as well as High Court. So there are different steps through which a judge can be removed. So here we will be looking one by one. So let's begin with the first step. The first step is if a notice is given of a motion for presenting an address to the President praying for the removal of a judge, then it must be signed by. Now you pay attention. If a motion or notice basically given to the President, then it must be signed by. In case if a notice is given in the House of the People, that is Lok Sabha or lower house, so if the motion is presented in the Lok Sabha, then minimum 100 members have to sign on that or else it won't be valid. Or in the case of notice is given in the Council of State, that is Rajya Sabha or upper house, then not less than 50 members of that council. So if the motion is presented in the Rajya Sabha, then 50 members have to sign on that. Only then it will be valid. It may be greater than 50 but not less than that. Now come to the step second, that is after receiving this such motion duly signed by the required members, the speaker in case of Lok Sabha, because we know the presiding officer of the Lok Sabha is a speaker. So, it must be a speaker only, or chairman in case of Rajya Sabha. So, the presiding officer of Rajya Sabha is chairman. So, it is chairman. After consulting such persons, if any as he thinks fit, and after considering such materials, if any as may be available to him, either admit the motion or may reject the motion. It is saying that once the motion presented to either a speaker in case of Lok Sabha or chairman in case of Rajya Sabha, then based on his knowledge, his experience or his expertization, he may consult some other person as well, or he can consult some material as well, and based on that he can either reject that motion or accept that motion. Likewise, if the motion is rejected, the story ends here. No further discussion on this. However, if motion admitted, then the process will proceed. So, there is chance that the motion can be rejected here only. Take the example of the former Chief Justice of India, that is Deepak Mishra. He was impeached, means impeachment process is initiated against him, but it is introduced first in the Rajya Sabha, so chairman that refused to admit that, so it didn't proceed. Now come to the next step, step 3. In case if motion is accepted, the speaker or the chairman, as the case may be, keep the motion pending. If he accepts, then keep the motion pending and will constitute a committee for the purpose of making an investigation into the grounds on which the removal of judge is prayed for. So, it is saying that either chairman or a speaker, whatever the case may be, will keep that motion in pending and constitute a committee. Okay. Now, let us check out who are the members of that committee. One shall be chosen from among the Chief Justice and other judges of the Supreme Court. The second one is, one shall be chosen from among the Chief Justices of the High Courts, and one shall be a person who is, in the opinion of the speaker or, as the case may be, the chairman, a distinguished jurist. So, the member of this committee will be Supreme Court's judges, basically judge, High Court's Chief Justice of any of the High Courts, and a distinguished jurist. Now, after formation of the committee, let us check out the step 4. In step 4, the committee shall frame definite charges against the judge on the basis of which the investigation is proposed to be held. So, based on the motion that is presented and whatever the charges presented in that motion, the committee will frame the charges accordingly. Now, let us check out the step 5. In step 5, such charges together with a statement of the grounds on which each such charge is based shall be communicated to the judge, and he shall be given a reasonable opportunity of presenting a written statement of defense within such a time as may be specified in this behalf of the committee. So, in step 5, this provision is saying that the committee will frame the charge and will give the opportunity to that particular judge against whom the motion is presented, and he will be given the chance to present himself, his innocency and all. Now, let us check out the step 6. In step 6, the committee may, after considering the written statement of the judge and the medical report, if any, amend the charges framed, and in such case the judge shall be given a reasonable opportunity of presenting a fresh written statement in defense. So, in step 6, what happens if there is any medical report of that judge or any such report or any such finding after the investigation, then in charges that will be updated accordingly. Secondly, after this amendment, the judge, that is against whom the motion is presented, will given another chance or another opportunity to present or to defend himself, and he has to present his defense in written. So, now check out the next step, that is step 7. In step 7, at the conclusion of the investigation, the committee shall submit its report to the speaker or, as the case may be, to the chairman, stating therein its findings on each of the charges separately, with such observation on the whole case as it thinks fit. So, step 7 is saying simply that whatever the investigation findings that committee found, they will accordingly prepare the report, and that report will be presented or submitted to the chairman or the speaker, whatever the case may be. Now, let us check out the step 8. The speaker or the chairman, as the case may be, shall cause the report submitted as soon as may be before the House of the People or the Council of States respectively. Now, let us check out the step 9. Step 9 says, if the report of the committee contains a finding that the judge is not guilty of any misbehavior or does not suffer from any incapacity, then no further steps shall be taken in either House of Parliament in relation to the report, and the motion pending in the House or the Houses of Parliament shall not be proceeded with. So, based on that report, if that report is proved that that judge is not guilty, then the story again ends here only. But if that report is positive, then if the report of the committee contains a finding that the judge is guilty of any misbehavior or suffers from any incapacity, then the motion shall, together with the report of the committee, be taken up for consideration by the House or the Houses of Parliament in which it is pending. So, whatever the case may be, whether it is Rajya Sabha or Lok Sabha, where it is pending, the report is presented in that house, and accordingly members will discuss that report, they will vote. As we know that we need to have at least 2/3 majority, that is present and voting in favor of that motion, only then that judge supposed to be removed. So, this process now will start, and once it is passed in the first house, that is where it is presented, then it will go to the second house. I mean, if it is presented in the Rajya Sabha, Rajya Sabha has passed it with 2/3 majority, then it will go to Lok Sabha, and Lok Sabha has to pass that with 2/3 majority. So, now let us check out the step 10. If the motion is adopted by each of House of Parliament in accordance with the provision of clause 4 of article 124, remember, or as the case may be in accordance with that clause, read with article 218 of the Constitution, that is in case of if the judge is of High Court, then the misbehavior or incapacity of the judge shall be deemed to have been proved, and an address praying for the removal of the judge shall be presented in the prescribed manner to the President by each House of Parliament in the same session in which the motion has been adopted. So, if everything is going fine, then the President will sign over that and the judge is supposed to be removed. But here one point more that you need to pay attention, that is mentioned as you can see on the board, that is same session. What it means? Parliament has different sessions. So in which session it is presented, it has to be passed in the same session. If session is changed, then the whole procedure has to be initiated again. So this is another condition, do not forget that. So this is all about the removal of the judges of the Supreme Court as well as the High Court, as the process are literally same. See you in next video.